Thank you, Christina. We now are looking forward to the comments by our commentator. He is Jiři Přibáň, who graduated from Charles University in Prague, and after a stint at Cardiff University, he was appointed in 2002 as a professor of legal philosophy and sociology at Charles University by no one less than Václav Havel, whom we all heard about. He's very much an international scholar. He's been at the European University Institute in Florence, at Berkeley, at San Francisco, Pretoria, New South Wales. He has come around in the world. He is the editor of the Journal of Law and Society. And he is, and I hope you appreciate that term, one might say a public intellectual who regularly contributes to the BBC World Service, to Czech television, newspapers, other periodicals. But today, he wants to contribute to our panel, and so we are honored by that. Thank you, Jiři.
Thank you very much, and I promise I'll contribute only briefly because we've just heard three very rich and complex presentations, and I wouldn't dare commenting on all issues raised by our speakers, and for me it was quite a learning experience. So very briefly, plus I'll be commenting on the three papers we've just heard, and briefly on Hannes Püchel's coming to terms with the past through penal law, denial of historical atrocities in Central and Eastern European penal law. Listening to these three presentations, I was wondering about some overarching or general themes underlying the presentations, and certainly there are, you can find them. One is the function of law and judicial review, constitutional courts, international judicial bodies, or national judiciary. So the question is function, then temporality, dealing with time, transitional justice against ordinary legal remedies. Symbols are very important. We're talking about red, brown in terms of colors, about swastikas, red stars, and these are symbols. So apart from function, time, symbols, we have ideology, politics, and judicial politics as ideology, as we heard from the last speaker. It can be surprisingly close from legal proceedings and decision-making to political identity. So I'll try to summarize briefly. The question is whether judges and courts can act as moral legislators. What Alexandra presented was a big question. How do you deal with different pasts? And she is quoting Justice Župančić, who is asking a rhetorical question in the Latvian case. Are we here to correct the historical wrongs? And of course, the answer to this would be simple. This is the first job of a judge, of a court, to remedy some wrongs which happened. And it's always happened in the past. You can't, but of course the question is more complicated, more complex, because the question arises, how do you deal with acts, and especially ideologies and consequences and contexts of the past, which is totalitarian and authoritarian, certainly non-democratic. My question, rhetorical question would be, isn't it quite hard for the European Court of Human Rights, and we can be very critical of the court, but isn't it quite hard, and aren't we asking too much when we want them to handle this judgment on the political past, totalitarian past, in broad, general, symbolic terms? Because the history of, and I certainly don't want to make just a simple judgment that Nazism equals communism. This is one gross simplification, unjustifiable. The second was that actually these systems are so different that nothing happened and there are some very positive things. Yeah. Hitler provided full employment, Stalin built canals, and so there's, as I heard, unfortunately, one Chinese scholar saying some bad things are being said now about Mao, but Mao kept the nation fit. And those who couldn't keep fit simply didn't have a place in the nation. But the question is, can we really demand courts to act as, switch from their legal role to the ethical role, which is something which Mark asks in his presentation. Mark's presentation was a fascinating meeting point of international theory of rights, transitional justice, and international law. The question which arises is, however, I know you criticize the leftist thinkers, but I still can't help myself and ask the question which Ran Hirschel asked. If we let this juristocracy reign, aren't we really impoverishing and putting something at stake? And transitional, I remember vividly responses to the arrest warrant made by Justice Garçon to General Pinochet. And I remember how even very liberal thinkers or pro-rights activists, such as Adam Michnik, saying, this is all wrong. It sends one simple message. If you are a tyrant, never leave. Always stick to your job. Because if you resign, if you go through peace negotiations, if you go through the transition, you never know what is your future fate. And so aren't we actually turning these judges into moralists? And we know that ethics is very important, but it's a high explosive like truth. Because if you have moral right, not just legal right, if you have moral right, you have moral duty, and your opponent is immoral. The biggest problem with the human rights discourse is that it almost invites adherents of the human rights to say that the other party is not human because they are not on the side of humanity. And I'm saying that as a person for whom human rights are extremely dear. But there is an intrinsic risk. Well, Mark also mentioned something very important, which is this transitional justice and legal remedy is actually a link between future and the past. And this is the dilemma which I just highlighted. Do you want brighter future, or do you want to do justice to the past atrocities? And very often very bad atrocities happened. There's no question about it. Nobody could deny that Pinochet was responsible for the worst forms of brutal political violence. However, isn't it price to pay if you want to have transition to democracy? And if you consolidate democracy, can you really arrest and judge? Can you really, and I'm asking it as a rhetorical question, can you really arrest and criminally punish those who started the roundtable talks and made the transition possible? An extreme example would be, should you try Gorbachev for sending troops to the Baltic states in the 1989? No, but there were clashes even before that, wasn't there? Yeah, the people who died were 1991 and before the independence. Yeah, but okay. I know I have to speed up a bit. Symbols, clearly, this is a piece which is a center part of Hannes Püschel. We heard about it. It's again part of Alexandra's presentation. Hannes Püschel asked about red, brown, and what should be made punishable. We have to remember the denial of Holocaust is not a crime in all European countries. Unfortunately, I live in the country which produces probably more Holocaust deniers per capita than any other country in Europe. I'm talking about Britain, not Czech Republic. I'm talking about Britain. And I don't mean just those people from diasporas, Islamists. I'm talking about old-style, extreme right-wing, neo-Nazi scene, which is particularly strong in some parts of British society. And yet when Irving was imprisoned in Austria, even the liberal press says, oh, isn't it too much? It's not right. Yeah? It's not right to punish the Holocaust denier because they are stupid and we should let them prove stupid in public. Okay, so, and I think Hannes nicely drew a fine line between words and deeds. And it's almost like back to the jurisprudence of what should be punished by criminal law measures and what should be left out of criminal justice. Simply, what is important is the difference between glorification of the past as such, which you have ever in Spain. If you meet some people, say, "Oh, it would never happen under Franco." What they mean, basically, this current mess is horrible, and in good old days, yeah, or under Mussolini, trains were always on time. Yeah? What does it amount to? And I think Hannes's piece draws the fine line between deeds and glorification of deeds which were crimes, which were criminal. Yes, I completely agree with my Polish friends that it's shameful for Europe that atrocities of Katyń are not part of European public memory. Because it was atrocity on large scale. Yes, oh, come on. So the glorification of deeds and glorification of ideas is also a different matter. Totalitarian ideology, so it's typical for Alexandra Hannes, which brings me to Christiane's piece on. I was wondering why using political activist book by Edward Said on Orientalism, which is methodologically flawed, and it's just a mixture, eclectic mixture of Foucauldian critique of discourse and post-colonial studies, which I think has one very good job, that it tells the Western Europe that its past isn't so bright as it might think, because the colonial past is quite a shameful past. But there is a German expression, isn't there? Drang nach Osten. And Drang nach was the German unification rather Drang nach Osten, basically, which takes me back a step back perhaps from identity politics and more into politics of resources, staffing, institutional redesign, and converting East Germans into second-class citizens by means of sheer drive into the new state building by Drang nach Osten. You just expand to the east. And therefore, less to do with identity, more to do with resources, power politics. The use of Radbruch is interesting because it brings me the full circle here, because it was used during denazification, and it was used during the decommunization. And I think there are some jurisprudential questions about Radbruch formula. Is it really just about predictability? Because every time I read Radbruch, I say to myself, well, an English jurist would never have a problem, would never understand the formula, because for an English jurist, the concept of natural justice always prevails in judicial decision-making. Isn't the Radbruch formula actually just an implementation of the principle of natural justice into the continental legalistic systems of law, which then makes it absolutely, which then makes it simple to understand it as part of the change in the style of argumentation, legal interpretation, and in particular constitutional interpretation. And one of the most remarkable things about denazification is that actually Germany, for the first time in its history, was successfully converted into constitutional democracy and the Rechtsstaat as the constitutional state. And you're absolutely right that, elements of Rechtsstaat are to be found everywhere. My Hungarian colleagues would say by the late 1980s, Hungary was a Rechtsstaat with some minor deficiencies and abuses of power. But the vast field of legal application was Rechtsstaat, they would claim. I'm asking one specific question. Telephone justice in East Germany. Wasn't it exactly the principle of telephone justice which then led so many people to addressing the problem of the socialist rule of law as Unrechtsstaat, because it was the law suffering from profound and systemically applied arbitrariness of law, which was always present there and which then compromises the socialist legal systems as the Rechtsstaat systems. Okay, thank you very much.